Welcome to my page. Here I will help you with your property journey. Wales has completely revolutionised its eviction system with the introduction of Section 173 notices under the Renting Homes Wales Act 2016. And if you're still thinking about evictions in terms of the old Section 21 notices from England or pre-2022 Wales, you're operating with outdated information that could cost you months of delays and thousands of pounds in legal fees. But the Section 173 notice represents a fundamental shift in how landlords can end tenancies in Wales, with dramatically different timing requirements, procedural obligations, and strategic considerations that affect every aspect of property management, from cash flow planning to tenant selection. The timing restrictions around Section 173 notices create significant strategic challenges that many landlords don't fully appreciate until they're caught in problematic situations. You cannot serve a Section 173 notice during the first 6 months of occupation under any circumstances, which means new tenancies have an effective minimum guaranteed period of 1 year, 6 months before you can serve notice, plus 6 months notice period. If you're dealing with problematic tenants who cause issues early in the tenancy, you have no quick exit strategy and must either work through the problems or pursue the much more complex and expensive fault-based possession proceedings under different sections of the Act. The procedural requirements for Section 173 notices are far more stringent than the old Section 21 system and leave no room for the kind of informal approaches that some landlords used previously. The notice must be in the prescribed form set out in Welsh regulations, using exact wording and formatting requirements that cannot be varied or customised. You must serve the notice correctly using approved methods, which typically means personal service, recorded delivery, or other methods that provide clear evidence of service. The notice must specify the exact date when possession is required, which cannot be less than 6 months from service, and must include specific information about the tenant's rights and available support services. Perhaps most importantly, you can only serve a Section 173 notice if you haven't breached any of your fundamental obligations as a landlord, which creates a much higher compliance threshold than existed under previous systems. This means your property must meet all fitness for human habitation standards, you must have provided all required documentation, including written statements and safety certificates, deposits must be properly protected with all required information provided to tenants, and you must not have committed any retaliatory actions against tenants who have exercised their rights. Even minor compliance failures can invalidate Section 173 notices and force you to start the entire process again, adding another 6 months to your timeline. The interaction between Section 173 notices and other possession grounds creates additional complexity that many landlords overlook. If you have grounds for mandatory possession due to serious rent arrears or other tenant breaches, pursuing Section 173 notice proceedings may actually be counterproductive because it signals to the courts that you don't consider the tenant's behaviour serious enough to warrant immediate possession. Conversely, if you serve a Section 173 notice and then tenant problems develop, you may need to abandon the Section 173 proceedings and start fresh with different grounds, adding even more delay to the process. Common mistakes with Section 173 notices include serving notices too early in the tenancy period, using incorrect or outdated forms that don't comply with current Welsh regulations, failing to properly document service of the notice, serving notices when compliance issues exist that invalidate the process, and misunderstanding the interaction with other possession procedures. Each of these mistakes can result in months of additional delays and substantial legal costs, making proper preparation and professional advice essential for successful possession proceedings. For landlords operating both in Wales and England, the differences in eviction procedures create significant operational challenges. You cannot use the same notice forms, timing calculations, or procedural approaches in both jurisdictions, and mixing up the requirements can result in invalid notices and failed possession proceedings. Many landlords find it helpful to work with legal professionals who specialise in Welsh property law to ensure proper compliance with Section 173 requirements. The strategic implications of the new eviction rules extend to tenant selection and tenancy management practices. Many landlords are now placing greater emphasis on comprehensive tenant referencing and background checks, given the extended commitment involved in each tenancy. Some are also implementing more proactive tenancy management approaches, including regular property inspections and early intervention when issues arise, to avoid situations where possession proceedings become necessary. Thank you for watching this video. Please subscribe to the channel so you don't miss the next video, and if you found this useful, please like it or share it with friends and family who would benefit from the content.